Hello and welcome to the show, KA Investigates. I'm your host, KA, and today I'm going to take quite a deep dive into a rather recently released judgment out of the New Zealand Employment Court. Just take you to a slideshow. And this is a matter regarding GF versus the Comptroller, or the Chief Executive, I suppose, of the New Zealand Customs Service. And we're going to look at the judgment of Employment Court Chief Judge Christina Ingalls. Now, I've had a look at this judgment and it's quite lengthy. It's almost 60 pages. So there's an aspect of the judgment that I really want to drill down on. So I'll just give you a rundown of what the case was about. And I'll refer to Judge Christina Ingalls in her own words and the introduction she wrote for the judgment released on June 30th, 2023. So GF is the plaintiff in this matter. It's in the Employment Court, and that person has permanent name suppression. So they can't be named, and even if someone knew their name, you can't pass it on or publish it in any way. So they are referred to GF throughout the whole judgment. So this is Judge Ingalls' words. The New Zealand Customs Service is a government department predominantly focused on supporting the safety and security of New Zealand's borders. There are a variety of roles within customs, including officers who work at international airports and at the ports. By 2019, COVID-19 was a known threat. It had not yet entered New Zealand. The government was concerned to take steps to keep COVID-19 from breaching the borders and to stamp it out if the breach occurred. This approach required additional resources across government agencies, including customs, and a number of border protection workers were employed on fixed-term employment agreements. They were known as Assistant Customs Officers Maritime Border, or ACOMs, ACOM. GF was appointed to an ACOM role at a South Island port in October 2020. The government introduced a vaccination program which was rolled out to frontline workers, including those working in managed isolation facilities. The rollout was informed by a cross-agency assessment tool that had earlier been developed, and that's referred to as the 18th of February 2021 guidance. This guidance was used by Customs to inform decision-making around which of its workers would be captured in the initial rollout, identified as Tier 1 workers. Customs considered the ACOMs fell within the Tier 1 group and had to be vaccinated if they were to continue in their role. Customs was well aware that there may be some resistance to the rollout amongst staff. This is Judge Ingalls speaking. It adopted a three-pronged strategy: educate, expect, and support. The strategy had a national focus across customs, and it was a strategy that was being advanced with other public sector border agencies. GF was not what was later described as vaccine hesitant. GF did not wish to be vaccinated and did not consider it necessary that their work be performed by a vaccinated worker. Ultimately, GF and 4 other ACOMs, or Assistant Customs Officers, from the same port who had also chosen not to be vaccinated were invited to a meeting. At the conclusion of the meeting, GF was given a notice of termination of their employment. GF pursued a claim in the Employment Relations Authority, and just as an aside, the Employment Relations Authority is like a tribunal. So generally it's lay people that are hearing the cases that come before it, and it's a step usually required before a case goes into the Employment Court. So I'll go back to Judge Ingalls' decision. The authority dismissed the claim. It found that Customs had acted as a fair and reasonable employer in the circumstances. GF challenged the determination by way of de novo hearing. And my understanding of a de novo hearing is that it's where you can bring your case again right from the start. So there's no prejudice attached to the prior decision, and you can have it heard afresh, in this case, in the employment court. So Judge Ingalls summarizes GF's case, saying that GF alleges that while Customs was operating in a novel and challenging environment, it failed to meet the standard required of a fair and reasonable employer in a number of ways. It failed to appropriately engage with GF on issues which impacted on their employment. It carried out a deficient health and safety risk assessment and proceeded to rely on it. It mischaracterized GF as falling within the Tier 1 group. It predetermined the outcome of a process which was marred with procedural errors, and it failed to comply with Tikanga values it had voluntarily imported into its employment relationships with staff. Further, it is said that as a public service organisation for the purposes of the Public Service Act 2020, Customs had heightened obligations on it which it failed to meet. Now, on the other side, Customs strongly opposed the plaintiff's claim. It submitted that it was entitled to take a cautious approach to issues relating to health and safety within the context of a developing pandemic, and that it was operating in a highly pressurized environment. It said that it provided an adequate opportunity for engagement, and that it was GF who refused to effectively participate. It disagreed with the contention that it was required to meet a higher standard in employment matters, either by virtue of having incorporated Tikanga or Tikanga values as part of the way it undertook to engage with staff, or by virtue of being a public service organisation. It did not accept that the process leading to GF's dismissal was flawed, and to the extent that there were any procedural deficiencies, they were said to be minor and did not result in GF being unjustifiably dismissed or disadvantaged. Lastly, it said that regardless of the process, the decision to dismiss was ultimately correct from both a health and safety and legal perspective, and that it would have been unlawful to allow GF to continue working. So the judge summarizes her decision. I have concluded that GF was unjustifiably dismissed and suffered unjustifiable disadvantage. In summary, I have concluded that GF was unjustifiably dismissed and suffered unjustifiable disadvantage. Customs did not act as a fair and reasonable employer at the time and breached its obligations of good faith to GF. Customs failed to follow a fair and reasonable process, failed to adequately engage with GF in accordance with the applicable requirements, and the decision to terminate was predetermined and fatally flawed. In addition to falling short of the baseline standard, I have also concluded that Customs did not meet what I referred to as the heightened good employer obligations imposed on it under Section 73 of the Public Service Act. Having gone on the front foot and incorporated Tikanga values into its employment relationship, it then failed to comply with them, breaching its obligations to GF. So that's the case in a nutshell. And even though there are issues relating to unjustifiable disadvantage and unjustified dismissal, it's the Tikanga issues that I really want to focus on. I'm going to go on to the next slide and we'll just start exploring what this all means. So what is Tikanga? I think that's a very good starting point for us. So I've sourced this through Wikipedia, but I know that it's a fair summation of what Tikanga is. And it's a Maori term that encompasses Maori law, customary practices, attitudes, and principles. It's derived from the Maori word tika, which means right or correct. So it involves moral judgments about the right way of doing something. Tikanga guides interpersonal relationships, interactions at meetings, and provides identity to individuals. So when you're looking at the context of an employment relationship, then if an employer has incorporated tikanga into the employment relationship, then that tikanga should guide how those relationships function, how they interact with each other at meetings, and how they give identity to those individuals. And it's also viewed as a practice code of conduct and is linked to the concept of mana. So in this court case, Customs had some documents. We've got their statement of intent from 2019 to 2023, which reflected the principles of partnership, protection, and participation based on the Treaty of Waitangi. And they also had their own values. We do what's right, we are guardians, we value people, and we look forward. So in the case before her, Judge Ingalls made these observations: that the court herself did not decide what tikanga or its values were, that she had to consider tikanga based on the evidence presented that was relevant to this particular case. She said that she needed to seek tikanga expert reports that were necessary when tikanga was relevant to the fundamental issues before her, and these were especially required when there is a lack of expert evidence or dispute on tikanga. And then that ensured proper consideration of the matters raised. And she identified that caution was needed in complex tikanga cases, and that there was a need for appropriate mechanisms and processes and safeguards to ensure proper consideration of tikanga. So she was very careful. So in terms of the expert evidence regarding tikanga that was introduced to the court, that came in the form of GF's expert witness, a Mr. Mayor, and he was called as a pukenga to give evidence. Interestingly, Customs not only didn't challenge Mr. Mayor's expertise, it didn't cross-examine his evidence per witness. Customs did not call their own tikanga expert witness. Another term that's going to crop up in this decision is te ao Māori. And what is te ao Māori? Well, it's the Maori worldview. Māori acknowledge the interconnectedness and interrelationship of all living and non-living things. So it's talked about that sometimes you have to look at things through a te ao Māori lens. That is how they view the world and how they fit in with it in terms of the land, living things like water, the air that we breathe, and also spiritual things beyond the realm of what we can see. So Customs relied on its interpretation of its documents and what it meant them to mean. So Customs said as principles that incorporated this te ao Māori perspective, and it was expressed in these relevant employment documentations, but they were values. They themselves, these principles were values. They weren't actually tikanga, and they had to be interpreted and applied depending on the context of the situation. Customs argued that those principles or values were only to serve as a guide to how they interacted with staff. They broadly expressed aspirational statements, but they weren't obligations that Customs was required to meet. So Customs argued that in terms of its interactions with GF, it had engaged respectfully and meaningfully, and that it had acted in accordance with its principles and values, but it refuted the general application that tikanga was part of this case, and it also noted that GF did not request the application of tikanga in the employment relationship. So Mr. Meir, who was the tikanga expert witness for GF, had gone through Customs documents, and he advised the court that these values or principles were tikanga. They were based on tikanga, and that because they were included in the employment agreement, then they had to, Customs was required to regard these tikanga values through a te ao Māori lens, and that they couldn't just take Pākehā concepts or non-Maori concepts and translate them into te reo, which is the Māori language. So Mr. Meir said that in terms of tikanga and the employment relationship, as an employer, Customs had to ensure that it made an effort in that relationship from the day that GF was employed until the day that the employment contract or employment relationship ended, because the maintenance of relationships is central to tikanga. And Mr. Meir said that that would have required face-to-face discussions with affected employees to reach consensus about their employment situation, and it had to be an individualized process. And Mr. Meir said that, in actual fact, that tikanga required post-termination care. So even after the employment relationship had ended, Customs was still had obligations to ensure the well-being of GF after that employment contract had ended. So GF's barristers argued to the court that Customs had integrated tikanga values into the employment relationship, and that Customs therefore couldn't interpret and apply those values as it saw fit. That having committed to tikanga in the employment relationship, it had to act in accordance with tikanga, and the flexible guideline approach by Customs was inappropriate. And they also argued that Customs must acknowledge and consider tikanga values introduced into employment relationships, and that it should inform its conduct with those applicable tikanga values. So the other thing that was argued on behalf of GF was that Customs, having integrated those tikanga values into its employment relationship with all staff, couldn't then limit those commitments to Māori staff only. And it seemed that Customs, through its case as it played out in court, had somehow claimed that the tikangas did not apply to certain staff, in this case GF, but then they asserted that they had actually adhered to those tikanga principles through the process of terminating GF's employment. And they went on to argue that witnesses for Customs had emphasised customs adherence to tikanga in their process with GF. So it's as though they had a stance. On the one hand, customs was arguing that it didn't have tikanga values in its employment contract, but on the other hand, that in dealing with GF, that it had adhered to tikanga. Strange. The judge also rejected customs' assertion that it was on a journey to understanding tikanga, and that having incorporated the tikanga values into the employment relationship, it was on customs to understand what those values meant and act accordingly. So in conclusion, the judge really rapped customs over the knuckles with how it treated GF. So in terms of its approach to the employment relationship, which Mr. Mayor, the expert witness, said should have been mana enhancing, if you will, that GF shouldn't have felt bad about the process or shouldn't have felt any less of a person because they should have felt respected. And having read the judgment right through, GF was really affected by how the process had played out. It had been rushed, it hadn't been fair, and they'd felt really isolated. And so that process obviously wasn't informed by tikanga. And the judge says this, that customs failed to individualize the issue with GF and lacked mana enhancing engagement. With the processes, it was unnecessarily rushed, and it didn't adequately involve the right people. So judgment said that to adhere to tikanga, well, this is what Mr. Mayor said, that in that meeting, I think it was on April the 29th, they had these, I'm going to say head honchos, these manager people having a meeting with GF and their colleagues. And GF didn't have a personal relationship with these people. So it was an employment meeting that ended basically with GF's termination. But GF's line manager, like their direct supervisor, wasn't involved, someone that they had a day-to-day relationship with. And so that was a failure for not having the right people there to support GF. And then the judge also found that customs had failed in its communication, that it refused to pause the process for further discussion. So GF's employment advocate had said, well, you're going too fast. Can we stop this, put it on hold and go to mediation? And customs refused. And then customs gave GF insufficient time to consider the vaccination order. The vaccination order actually came out on the day of the termination meetings, and they had the meeting, and then GF was basically terminated at the end of it. So I think what interests me in this case is not the fact about just employers being aware of what their obligations are in terms of tikanga and if it's incorporated into employment relationships. But I think the fundamental is that it's actually that it actually applies to all employees, whether or not they're Maori. And I can understand the sense of frustration that non-Maori employees might feel if, like customs, an employer appears to give Maori employees more support and engage with them more appropriately, because tikanga is influencing or informing the way they behave with Māori employees, which they then don't mirror with non-Māori employees. But this judgment says the opposite is true, that if you've got tikanga embedded in your employment relationship, then it applies to all employees. And I think it's cringe that Customs argued in open court that GF wasn't afforded these values, or to have their relationship with Customs valued in the same way that Customs valued its employment relationships with Māori. It's a terrible, terrible message to send to employees. And I think more New Zealanders need to understand that what they potentially believe is preferential treatment. In actual fact, it's the employer not understanding its obligations, and they should be challenging it more. I found that the local media hadn't really covered this case at all. There's far more to it. Oh, the way the process went, it was terrible. So I might do another video just based on what went wrong, because the judge, I can tell you, she was not impressed by any Customs witness. And the judgment is really scathing of Customs, and how it got to the point that it went all the way to a trial, and then this judgment came out. It's not flash, it's not a good look. So I might do a video one day just looking into those other aspects of the case as it played out. So thank you for joining me in this video, and I look forward to seeing you the next time. Bye.